All right, hello. Hello and welcome. Hello, welcome. Thank you so much for joining me. Welcome to those on YouTube and Facebook and TikTok and Instagram. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And welcome. Thank you so much for being here. Today is the 30th of August. And we're here live, and so really welcome. Thank you for being here. It's a beautiful Tuesday morning here in the Bay. This is the Deportation Defense Live. Today our theme is common problems in cancellation of removal cases. So we'll talk about that today, and then we'll get into any questions that you have. All right, and so welcome and thank you for being here. All right, remember that the Deportation Defense Live is here to train, to teach, to inspire, and to empower immigrants who are facing deportation to make the most out of immigration law, to make the most out of their lives, and to win their cases. All right? Are you facing removal in immigration court? Do you know someone who's facing removal in immigration court? Because if so, you know that it's not easy. All right? It's an uphill battle. The laws are against us. And here at the Deportation Defense Live, we are here to maximize your chances of winning that case. That's what this is all about. All right? Today, our theme is common problems in cancellation of removal cases. And thanks to everybody that submitted their question. And if you have a question, hey, send me your question. All right? We've got 30 minutes to discuss this topic in English, and then we'll do this episode in Spanish. And so welcome, and thank you for being here. Before we get into the topic, I want to discuss the basics real quick. What are we talking about when we say cancellation of removal? All right? Well, cancellation is actually a broader term. There's several different types of cancellation. But the one that I'm focusing on today is what we call cancellation of removal for non-permanent residents. It's a E42B case, all right? And so there's four basic legal eligibility criteria to win cancellation of removal for somebody who's in immigration court, who's got hearings in front of an immigration judge. What are the big four? Number one criteria, you have to have 10 years of continuous physical presence in the United States. All right? People say, hey, I heard about the 10-year rule thing. This is what they're talking about. All right? But that's not the only requirement. It's not just like a way to win a case for being here for 10 years. That's only one of the four criteria. The second requirement to win cancellation is you've got to show for those 10 years that you've been a person of quote-unquote good moral character. All right? You got to show you're a person of good moral character. The third, and we'll discuss what that means. The third is often the hardest one, and that is that you have a U.S. citizen or a green card holding spouse, parent, or child who would suffer they call it an exceptional and an extremely unusual amount of hardship if you were deported. That's requirement number 3. And requirement number 4 is that you must merit a favorable exercise of discretion. Okay? And so if you have those big 4 criteria, then an immigration judge can and has the authority to cancel your deportation and approve you for a green card. Okay? And so that's what I'm talking about. That's what's commonly referred to as a cancellation case, or you might hear the term E42B, cancellation of removal. All right? The form is EOIR-42B, which is the form that's put out by EOIR, which is the Executive Office of Immigration Review, the immigration court system. Okay? So let's talk about the common problems that I see when I'm reviewing cancellation cases. And I review them to see if we could reopen them. I review them to see if we could improve them. I review them so that we can maximize our chances of having a strong strategy going forward, things like that. Common problem number one, all right, is not, and this is for lawyers, and it's also for people who are in this. You want to be aware, okay? Common problem number one that I see is not submitting enough evidence of the fact that you've been present in the U.S. for the last 10 years. All right, very basic, okay? In a cancellation case, you don't want to submit the minimum. You want to really establish so that the judge doesn't have to guess, right? There are judges that want to rule in your favor, and there are judges that don't want to rule in your favor. And so you want to document everything as much as possible, okay? So don't just submit tax returns for the last 10 years. Okay, don't just do that, right? Also, look at like whatever else you've got, rental payments, insurance payments, utility bills, maybe even photos that have date stamps from over the years. Like you want to submit a packet of documentation to establish that, like clearly, without any doubt, you were physically in the U.S., during all of the last 10 years before your notice to appear. Okay? So you want to really document it well. A well-presented cancellation case is submitted with a lot of documentation. Okay? All right, like sometimes, boxes worth of documentation. All right, common problem number two, all right, is not enough work is put into the good moral character requirement. All right, now let me take a step back here because some people get confused. Like good moral character as a requirement, you don't have to be a saint. You don't have to be Mother Teresa. You don't have to be the greatest person. You don't have to be active in your local church at all, right, to demonstrate good moral character. Also, it isn't a static requirement. Now, what do I mean by that? What I mean by that is, like, you can build your good moral character even during your case. And your lawyer should be explaining this to you, right? Your lawyer should be helping you think of ways to bolster your good moral character even while your case is going forward. Like, what can you do now? Like, an immigration case, these types of immigration cases often take years. So what can you be doing in the next 3-4 years, right? Like, participate in your kids' school and participate with your family and volunteer at a local shelter or food kitchen or, teach soccer or heck, play soccer, right? Learn English, take classes, do something productive. All of these things can help you document and show and demonstrate to the judge that, hey, you're wanting to present and show and establish that you have good moral character. All right? And while you're doing those things, while you're participating and volunteering, or even if it's at the job, be a strong worker, but go above and beyond. Show up early every day. Do what you can to really demonstrate that you're all in. All right, you're all in, going for it. And as you do those things, hey, ask where you're participating. Ask at work. Ask where, at your soccer team or at your English language class or whatever, wherever you're participating, ask the people there that you're meeting and making an impact to help you out also. Maybe they could write a letter. Maybe they could, share how you've been participating and how you've been being in each of those activities so that you can document your character. All right? Good. Good. We're making progress. So hello, if you're just joining me right now, thank you for joining me. I'm Otis Landerholm, Landerholm Immigration, A.P.C, where we fight for your American dream. We're live right now on YouTube, Facebook, Instagram, and TikTok. All right? Elvia and J4 and NF Tada. Hello on Instagram. I see you there. And hello, everyone on YouTube, Facebook, and TikTok. Send me your questions if you've got them. All right? And we're talking about cancellation of removal. I'm still going through it. And so I'll get right back to it. So common problem that I see when I'm reviewing a cancellation case, common problem number 3, all right, is that often I see it where there's just not enough evidence or not enough work that's put into the level of hardship, all right, that the court needs or that the court requires. Now, remember that the level of hardship to win this type of case, right, the way it's written into the law, it's not some hardship. It's not a lot of hardship. It's not extreme hardship. The term is exceptional and extremely unusual amount of hardship. So how do you document that crazy level that your spouse, parent, or child who's a U.S. citizen or a green card holder would suffer, right? It's a horrible thing, right? And it requires an extraordinary amount of attention to that requirement. And many lawyers out there, everybody knows that is the hard thing to show. And so a lot of lawyers out there solely focus on that requirement to the detriment of the other requirements, which is a mistake. But still, you want to think about what could you do to demonstrate and show and explain and argue that level of hardship. Like you want to think in terms of medical harm and financial harm and physical, emotional, psychological harm or impact. How would you be impacted in all of these ways? How would your spouse, parent, child, all of them, be impacted in all of those different ways if this case were denied, if you were ordered deported? How would their quality of life suffer, right? Would they be unable to pursue the career of their dreams? Would they lose out on their occupation or their career? Would they suffer emotionally and psychologically? Would they suffer medically for some reason? Are you their sole caretaker or provider? Would they suffer from their own physical safety? Maybe maybe your home country or country of origin is unsafe, or maybe there's societal unrest or war or gang violence or whatever this case may be. We want to think through all of that and put it all together. This is how, judge, this is how my spouse, parent, and or parents, child, and or children would all suffer harm if I were ordered removed. And all of these things added on top of each other amount to that level that is exceptional and extremely unusual hardship. That's the way to do it. All right, common problem number 4. We're making progress. Thanks for being here. I just got 2 more. Okay? So Common problem number 4 is often there's no thought put into the element of discretion. You know, these applications are discretionary. There are judges who are more immigrant friendly and more likely to approve your case, but there's also judges who are less so, right? They're less likely. And so you want to make sure to present your whole situation, showcase your whole life, showcase how, you want to take responsibility and ownership for any immigration law violation in the past. All right, and you want to say, despite that, you still warrant a favorable exercise of discretion, and here's why. All right, now, often if your good moral character evidence is strong, that will help the discretionary finding too, but you don't want to overlook one or the other of those elements. All right, they are not exactly the same, so you want to think about that. Common problem number 5 is strategic problems. All right, and we see this more often than it's unfortunate how often we see this. Let me put it that way. So, for example, somebody thinks that they're eligible for cancellation, and so sometimes they'll only file for cancellation, even if they might also have an eligibility for asylum, a U visa, a VAWA case, some other immigration benefit. If you just argue one, that sometimes is a very poor strategy. Like if you're facing deportation, you want to make every argument you can possibly make. And in fact, legally, cancellation of removal is the last of the applications that the immigration judge wants to evaluate. And so you really are advised to not just submit cancellation of removal. All right, you don't want to just submit cancellation. You want to submit everything that you are possibly eligible for to maximize your chances of winning. Okay? And the other one that we often see is related to prosecutorial discretion, right? Sometimes it's like, an attorney will recommend prosecutorial discretion and close the case. And sometimes it's like, that's a bad strategy too sometimes. Sometimes it's not. But sometimes it's like, man, you're closing your case when you could have won a green card. All right? Depending on the facts, depending on the strength of your case, sometimes you're better off fighting and winning than not fighting and just staying in some limbo. And so you really want to think through the strategy, and you want an attorney that knows what they're doing, who can really advise you on the strengths and the weaknesses of your particular situation, and think through, hey, what could we do working together as a team to address any weakness that might be in your case? Could we present an expert opinion, witness? Could we, get a psychological evaluation? Could we get medical records? What could we do to put the case together to maximize your chances of success? Okay, so that's really all I wanted to say about that topic. I talked a lot about it. So let me stop there about cancellation, and let me get into your questions, because I know people have questions. And so thank you. Thank you for being here. If you have questions, please send them in. All right. One question that I've received here is from Alma. Alma, thank you for your question. Alma, you say, I have been denied citizenship and my green card was found to be void. All right. Will that affect my husband's citizenship application? Okay, that's interesting. I'm sorry that you've been through that, Alma, and thank you for asking your question. That's really a tight spot to be in. My question for you is, was it USCIS that is saying that they've denied your citizenship and your green card was found to be void? Or was it an immigration judge that has agreed with that finding? Like, did they put you, if they say that your green card was void, typically, often that means that they'll put you into deportation proceedings. All right? But have they done that in your case? My second question is the question of, will that affect my husband's citizenship application? The question is was your husband's green card dependent on yours? Right? Was your husband a derivative on your green card case? How did your husband win his green card? If he won it through yours, and if yours was void, then his probably would be void also. At least it could be, right? And so that's something, you're going to want to talk to a lawyer. I'd love to help you with that. Like, let's really look at it and let's strategize. How can we really, either argue back and say, no, wait a second, this wasn't void. There's some problem with USCIS's interpretation or understanding of the facts. Or let's fight for your husband's case, or let's look for other options. That would be my assessment. So Alma, thank you for asking that. Let's see, Rocio, I see your question here. You say I got a work permit 2 years ago. After I get a work permit, how much time do I need to apply for residence? It depends on what kind of work permit it is. So Rocio, I don't know if is it through a U visa? Is it through a asylum case? What's your eligibility or a cancellation of removal case, for example? What type of work permit do you have? That would help me answer that question. All right, Riaz, I see your question. You say, my case was dismissed. Now, can I get my bail bond money back? So you should be able to. Yes, once your case is terminated and you're no longer in removal proceedings, in theory, you should be able to go back to ICE and have your sponsor, or the key word is an obligor, the person who's paid the bail bond for the immigration case. You should be able to get that money released. There's an ICE form to fill out to do that. And technically, it's the obligor, the person who paid the bond, who should go through that process to get the bail bond money back. All right? And so, yes. All right. Those are all of the questions that I've received today. Thank you so much for everyone for being here. Rocio, I didn't get a follow-up about your question, and it might be, let's see. Oh, it says U visa. I'm sorry. Okay, Rocio, you got a U visa. So the question there is, if it's the A19 category work permit, which is the U visa, all right? If that's what you've won, then the U visa law allows a person after 3 years to apply for adjustment, to apply for your green card, okay? So it's 3 years if it was the A19 category work permit through the U visa, all right? If it's an asylum case, an A5 category work permit through asylum, it's 1 year to be eligible to apply for your green card. Different categories have different legal requirements of what the wait is to apply for the green card, okay? So I hope this was helpful. All right, everyone, thank you all so much for being here. I really appreciate it. If you still have a question and if I haven't answered it, hey, I'd still love to answer it. Submit it and I'll still answer it. And the way to see those is to just subscribe to our channel in YouTube, all right? And then if you click the notifications bell, you'll receive a notification every time we upload a new video to YouTube. You'll also get additional legal news and updates as we, as we see them, all right? And as always, if you have an immigration case, if you have a cancellation of removal case, if you are in immigration court, if you need help with your immigration matter, please feel free to give us a call. We are here to help. And thank you so much for being here. My name is Otis Landerholm, Landerholm Immigration, A.P.C, where we fight for your American dream. And we'll see you next week on our next episode of Deportation Defense Live. Thanks a lot. Take care. Bye-bye.